Welcome to Zoom video conferencing. My name is Sean Neal from Woodshed Agency. We're an Oakland County media company that is helping out my guest here, Vaughn Dedarian, the chair of the Oakland County Democratic Party.
Hey, Sean, how you doing? Like you said, I'm the chair of the Oakland County Democratic Party, and we're going to be working to bring valuable information to Oakland County residents over the next few days and weeks, as we're all trying to figure out how to address the problems that we're all facing as we try and flatten the curve, as they say, and find ways to help our community weather the COVID-19 crisis.
Great. So we have a guest today, Tony Paris from Sugar Law, and we're going to let him introduce himself right now.
Okay, I'm Tony Paris. I'm the lead attorney at the Maurice and Jane Sugar Law Center for Economic and Social Justice. I've been an attorney here for about 12 years now. We're a nonprofit workers' rights law center that specializes in everything from plant closings and mass layoffs, unemployment insurance benefits, labor and employment law more generally, and usually we represent folks who are either unable to afford an attorney or have actually cases that might not receive a potential large contingency fee at the end of it, so it does not necessarily fit into the private market. We do a lot of work around underemployed workers, unemployed workers, and I've now specialized in unemployment benefits for at least 10 of the 12 years that I've been here, not only as a state advocate in these unemployment insurance hearings, but broadly, the Sugar Law Center is a national expert in the WARN Act, a rarely known federal law that deals with larger scale closings and layoffs that may affect working people in their communities.
Fantastic. So we're going through this coronavirus crisis, this global pandemic. What are some of the normal things that people should be expecting as they're being furloughed or laid off or not able to go to work right now? What kind of falls within the context of normal behavior right now?
So a normal thing that somebody may experience is either a downturn in their job or straight up communication from their employer that they are either going to be off of work indefinitely, off of work for a specific period of time, and maybe or may not the reason as to why that would be the case. Usually, unemployment insurance filings need to fall within one of three things: a layoff, which is also like a lack of work. I think that's going to be a very common category. A termination, or an employer actually says you do not have a job here any longer, whether it's for a reason or no reason. And a voluntary quit, something where a worker may want to or need to leave their job for whatever reason. One of those three boxes that are going to be checked when filing for unemployment affects what laws are going to apply to them and what their eligibility may entail.
Okay, so I would imagine that most people are going to be falling into this layoff category, with another chunk maybe where the business simply can't survive and there's no longer a job. What opportunities or actions are available to those two groups?
Okay, well, I'm going to kind of speak generally first. This would be the case for unemployment insurance eligibility, regardless of the fact that we're facing an unprecedented type of pandemic right now. Normally, if you knew that that the job that you were doing is no longer needed, usually this is what is called a layoff. However, sometimes people confuse a layoff, which is essentially a lack of work, with another type of separation. Under the layoff category, really, you're going to be eligible in a broader coverage. The employer might get notice that you filed for benefits and said they now have a lack of work. And the employer can always maybe dispute that, and that might affect your eligibility. But that being the initial box you check can oftentimes make things much more streamlined when filing for benefits.
Okay. So let's talk about the circumstances now. What type of worker typically qualifies for unemployment benefits under those normal conditions? What type of employment?
Okay, sure. This would be somebody who is told that there's going to be a temporary shutdown in the job, that the business needs to cease normal operations and their job is no longer needed for at least a specific time frame. It could be indefinitely as well. Generally, these are furloughed workers. These are workers who might actually be told that their plant is moving somewhere else further away, or their job is, closing down. Just generally that there's a lack of work and that there's nothing about the employee's performance that was at issue in making such a decision.
Okay. And what types of employment? Is this for hourly workers, salary workers, bar and restaurant people that work on tips, gig economy, like Lyft, Uber drivers?
Yes, that's a very great question, and an important question that specifically is going to change our answers a little bit as we talk specifically with COVID-19. Normally, this would affect any worker. Doesn't matter whether you're hourly or salary, doesn't matter whether you receive some of your wages from tips or commissions, but it would not normally apply to you if you are an independent contractor. Now, part of what we do at Sugar Law is make evaluations of whether employees are even properly classified as independent contractors to begin with. Because many folks don't know that if you're a contractor, virtually any and all labor laws that I would be discussing with you would not apply. You would just strictly be somebody who could only bring an action for a contract breach. You wouldn't apply for unemployment benefits, you wouldn't have discrimination protection, you wouldn't have the gauntlet of labor law. Now, what we are noticing, and I think it's a commendable act by both Governor Whitmer and federally, is a heightened concern for those workers in the gig economy who normally would not have any type of protections at all, potentially be eligible not only for some type of unemployment insurance benefit, but for other protections as well. Now, we saw the Senate pass today a stimulus act that specifically addresses those issues. I believe that Governor Whitmer's executive order did not expand unemployment coverage to contractors, but those contractors might see some relief through this stimulus once it's signed into law, hopefully this week. Normally, even if for some reason one of your viewers needs to know whether or not they could still potentially qualify as a contractor or as somebody who was, paid as a straight pay 1099 cash self-employed type of way, you would actually still maybe file for benefits initially. You would receive quickly a notice of a monetary determination. This document would then say, you have no wages reported from an employer into the state wage system. You are therefore eligible for $0 for your into the unemployment system. Now, that's standard for contractors because the employer has not been reporting any of the W-2 tax wages that it's required to do with regular exempt employees. But you're able to protest and appeal that determination, that monetary determination, by following the very simple instructions right there on the form. You don't need to wait for an attorney to help you with it. You would just need to provide some type of income, proof of income, some type of statement as to why you believe you are actually an employee. And the unemployment insurance agency at that time will engage in a decision of whether or not you were classified properly as an independent contractor, or whether or not your employer could still be on the hook for any unemployment benefits because you had been misclassified under the law. It's a test 8 to 10 point test regarding the control your employer has over you, regarding the equipment you might bring, regarding how you schedule yourself, whether you're able to hold yourself out into the public as doing other types of work. Various factors go into that decision, but my best advice to any of your viewers is to, when in doubt, file. Even before you get, we may get relief in the stimulus, when in doubt, file. And if you're denied, just protest up through the chain. After the determination comes a redetermination, which sometimes overturns their own decision denying you, but rarely that's the case. Usually it will take one more protest, a second protest, where you're then able to get a phone hearing or interview with an administrative law judge to actually go through the facts of your case, give testimony, have an attorney or advocate such as myself help you present your case, and actually put forth the proofs that you may have been misclassified, or even if it's not a misclassification issue in general, that you actually were laid off, or that you had to voluntarily leave for good cause, or that you were fired for without cause. Whatever it might be, after the second determination is protested, you get this notice of hearing, and that's when Sugar Law Center would get involved. The earlier stuff, you're under a 30-day deadline to protest, but we would just recommend that you protest that as soon as possible.
For people that are worried about that sort of about participating in that process, who might think that they're an independent contractor, they don't have any resources, they don't have anywhere to go, are there resources that we can give them that will help them kind of walk through the first steps of this process by themselves? Or is it something that they need direct help? I mean, would they need an attorney to begin those first steps, or are there things that they can do on their own to get the process started and hopefully get themselves to a point before they need to bring in outside counsel?
Sure. Definitely they can get the process going on their own to begin with. I think the unemployment insurance agency, for a misclassification issue of let's say a gig economy worker, would request any of your pay stubs to show income, would request some type of written statement that says, I actually believe I may have been misclassified. I was only ever working for this employer. My employer set my schedule. My employer directed me what to do every day. I don't have any other job. I don't hold myself out as being self-employed and painting houses elsewhere. My employer told me what to do and when to do it each time. It's a test that they can see some of the factors online, the broad factors. It's called the economics reality test. And it actually goes through the misclassification issue. But to get the ball moving, they would just need to show that income and everything long before there's a hearing involved. And usually, at least in the application process, there will be questions that the unemployment insurance agency is specifically asking, what I'm saying. Did you receive income? What are your earnings? To fill those out as truthfully as possible. And of course, if they got hung up on a question, a specific question, they could always contact us. But generally, the most important thing in getting the ball moving, especially because it's a pretty much potentially a very tenuous time frame that folks are in if they are not having any income coming in the meantime, is to just not take no for an answer and continue to protest regarding that. And we're still talking specifically with folks in the gig economy. A very similar procedure happens for just anybody filing for regular unemployment insurance benefits. However, it's going to be a little easier for those folks because under their social security number or the employer's employer ID number, there's already going to have or be a specific amount of wages that are quarterly reported by that employer that will show what that employee's weekly benefit amount would be, barring any other potential denial. That comes through in a monetary determination as well. It will give an amount between $0 and $362 a week, which is the max, currently the state max, where you're eligible based on whatever you were making before. And normally, depending on what the federal stimulus actually does, it was a max of 20 weeks that they could be eligible for during this time period. However, Governor Whitmer's executive order extends that to 26 weeks, bringing it back to what it was prior to Governor Snyder limiting it to 20 weeks. And federally, it's quite possible that there will be extensions that go on beyond the 26 weeks, which was the case when our economy had the crash and crisis during Obama's administration.
Yeah, I was going to
Okay.
say, I think that the benefits back in 2008, 2009 got extended all the way out to, I think, 52 weeks, maybe 78. It was a really
That's
long
right.
extension. And this
That's
is
right.
kind of the same situation where we're in a weird period where the people are not out of work because they don't want to be. They're out of work because we're all being told to stay in our houses and not go anywhere and not do anything.
That's right.
Great.
That's correct.
So Tony, I have gathered a list of 3 or 4 common categories that are not a typical W-2 hourly or salary worker. And I'd just like you to, based on the path you laid out, just let us know how likely they are to have to go through to filing 2 complaints or 2 responses, and likely have to seek out an attorney. So
Sure.
so the first category is anyone who is driving for Lyft, Uber, or doing any of the on-demand type food delivery services or delivery services.
Very common that they'll be denied, initially at least, in their monetary determination. This is the gig economy. These folks are probably paid from those apps in a straight pay 1099 without any taxes taken out, without any coverage of payroll exemptions. Those folks are very likely to have to either claim that they're misclassified and go through that type of procedure, or wait and see what this federal stimulus pass does for the gig economy. It specifically references that contractors and gig economy folks are going to be entitled to the same benefits for unemployment insurance, benefits that would extend to regular employees. Now, I'm very curious as to how this is going to work with the infrastructure and the system and the computer system that Michigan uses, whether there's going to be human beings that are able to trump any of the state's decisions that might happen initially. Back in 2012, the state of Michigan laid off over 400 claims examiners to put in a computer system called Midas. Midas is an automated system that still makes most of its determinations based on data and does not have human reviewers or any type of input from human beings. Whether or not this system can be programmed to adapt to federal law, whether or not this system is going to be able to take on all the additional filings that have happened is a separate story. But unfortunately, barring what happens federally with addressing these gig economy workers specifically, your first category of workers are going to be the most vulnerable and potentially most uncertain as to what types of benefits they may receive under Michigan law alone.
Okay. The next group are people that work in the service industry and might rent their workstation or space, specifically hairdressers, salon stylists, gym coaches, this kind of category that are working for a space but aren't necessarily an hourly worker and have their own clientele and commission-based earnings.
That's another great question. I would probably put them into the category of the first folks, with the caveat that I do see a lot more when workers are told to rent a truck, or they're just driving a truck that they rent, or even some hairstylists who get their appointments and schedules from the house, we'll call them, much more likely to potentially be misclassified. It is such a specific, fact-specific determination that it's hard for me to speak too broadly, but I do know that the evaluation will go through whether or not your schedules are still being received by the house, whether or not you receive a lot of your work from the house, whether or not the formality of having to bring your own equipment or your own scissors if you're a hairstylist is trumped at all by the fact that literally all of your clients come from them. Literally, you're not allowed to go home. You've signed something that says you can't go then also work out of your basement and cut hair.
Right.
Whatever level of control that the let's call them the parent or the house would have over you is the determining factor. The 8 to 10 factors used in the law are specific that say no one factor is determinative alone. Control is the general theme, but Uber and Lyft have made a very, very good market, unfortunately, at walking the line between contractor and not contractor. And I would imagine that most of the employers that we see slip up in this regard really don't understand the law that way. And so we'd look at it to say, okay, I'm a truck driver. I have to rent my space, but honestly, here are all the ways that the employer controls my route, what I'm taking, what I'm doing every single day. And that second category you mentioned would be more likely to potentially win at the Michigan benefit rule by protesting that monetary determination and putting forth all of the reasons and all the factors that are in their favor.
So my last category is a group of workers who had a contract or a promise of income, say like a videographer or a carpenter or a construction worker whose contract and project of work fell within the shutdown time frame, and now that contract is canceled. So they were booked planning on work and couldn't do the work because of, maybe they're installing a bathroom at a retailer that's now closed because of the shutdown, or one of those situations. How would that person seek compensation or seek lost wages?
Another great question. And really, the first inquiry or the first, I guess, prong of my evaluation in that would be whether or not this person was misclassified to begin with. If they, we do see it, although it's rare, that sometimes even W-2 employees are under a contract. Sometimes even folks who, are working. I just saw it the other day with a actual basketball coach for Central Michigan University. They were under a contract that now is going to be stopped because of the lack of college sports. And at first that threw me that like, they're going to have to get a misclassification problem or determination first because they're under a contract. But it was actually an employment contract, and they were W-2 employees with regular deductions taken out that were working full-time salary as assistant basketball coaches. Those folks really wouldn't have to worry at all. They would probably have a very easy time in filing for benefits, with the slight caveat that we'll see how Governor Whitmer and the federal stimulus addresses this. Normally, in order to receive unemployment, even when you're a W-2 employee, you have to have wages in the past 6 quarters or a year and a half. That is potentially disqualifying for a lot of workers who might be new to the workforce or have been previously off for a long time or contracting somewhere for a long time. There's another alternative way to qualify it where you have a certain high amount of income in one of those 6 quarters that is over a threshold. I don't know. It's usually a computer algorithm based on the median wage of the state, but you can qualify for unemployment under that alternative qualifier, even if you do not have the 6 quarters of wages. So barring that, W-2 employee, even under contract that's broken, regular layoff or lack of work, you're probably going to be fine. If this is a contractor, you just have a signed agreement as a self-employed contractor to do anything from, improvements on a home or whatever it is. If you're going to look at whether you're misclassified, and if it's not easy to argue that you were misclassified because it was a short part-time gig. You do other stuff all the time. You did want that income and relied on it, but you didn't have, the control over you that I'd previously mentioned. Then you're really going to need to hope that the federal stimulus applies to you. Because at the end of the day, I don't think the Michigan system is yet built without that federal stimulus to provide benefits to just straight contract workers. Governor Whitmer's executive order, it makes it clear that this does not necessarily yet expand any of those rights yet. And so once the federal stimulus happens, let's keep our fingers crossed for those folks.
Okay, great. So that actually answered my fourth question. Now my fifth question is, it sounds like a dispute of some kind with classification of your employment status is the path to remedy. Should any of these groups of workers be concerned about retaliation or blowback from their employer should they pursue this route?
Unfortunately, they should keep a close eye on any retaliation. Pretty much, it's a myth out there that employees pay into the system. I hear it all the time. I paid into unemployment. I'm entitled to it. That's just wrong. Unfortunately, this is an employer-funded payroll tax system, 100% employer-funded. And so employers have a very vested interest in not only denying unemployment, but into limiting the amount of workers that they have that could potentially draw unemployment. And we see this all the time where workers, long before COVID-19, I spent a good chunk of my day representing folks at unemployment hearings because an employer is disputing their unemployment insurance eligibility. Now, if the employee going to the government to exhaust one of their rights or potential rights. Either I'm misclassified or I'm going to go to the government, the state of Michigan, and say I'm misclassified, or I'll go to the Federal Department of Labor and say I am because I'm trying to file for unemployment insurance benefits. If they're retaliated against, it's likely that they will be protected by the Michigan Whistleblower Protection Act. That's a law that protects any employee in the state of Michigan who either goes to the government or tells their employer they're going to the government to address some type of issue, either misclassification, even if it's just reporting safety issues, even if it's reporting being part of an audit. It's very broad. The weak parts of that law are that it's a very quick statute of limitations, 90 days. So you would really have to see what you believe the employer would be doing in retaliation against you, connecting it to the fact that you're drawing benefits, or connecting it in some way causally to what benefits you're seeking from the government, and not for any other pretext. If the employer then pays closer attention to something else that might be a problem. These are issues that I litigate all the time, trying to prove whether the employer did this because they filed for unemployment or for some separate reason. But they should keep an eye on that. Keep an eye on demotions, being taken off the schedule, worse shifts, less hours, straight up termination, anything because they decided to actually pursue their potential rights to unemployment insurance benefits.
So with this crisis, most employers do not want to be closing up shop. They do not want to be laying off their workforce, right? So how should the employee approach this without being in contention or in conflict with an employer that they do enjoy working with and they know is not trying to hurt them?
It's an important question because I think the conflict that sometimes is inevitable in these situations does potentially end up costing both sides more time and money than I like to believe is always necessary. What I would recommend employees do who don't want that type of conflict is to keep lines of communication open with their employer as to what, if anything, might be available to them short of filing for unemployment. This could include maybe an employer has some type of PTO time for them, or some type of paid leave of a regular wage during this time period. Maybe it would include doing something at the job that's slightly different than what the job that's been effectually eliminated is. I've seen this from employees being offered to come in and clean or redo, parts of the business for the same wage, during this time period. I've actually encouraged a lot of employees to do some type of severance if they know they're likely to close or otherwise not reopen for the indefinite future, because a severance payment can offset and or delay unemployment insurance filings, especially if it's viewed as a pay in lieu of notice type of severance agreement. All of those options to keep the employment relationship as normal as possible as far as wages goes could really prevent any misclassification determination, could prevent the employer from eventually potentially having to be on the hook to pay all those weeks of back benefits when they haven't even paid into a system. And from the employee's point of view, to say or to think to themselves, if there's any way that they can use this time to figure out whether or not any other potential means of income can be used to offset this in the meantime. Short of 401ks and everything like that, you can see this being, other gig work or something else that they might be able to do to supplement their income with their employer. The unemployment insurance system builds in to it underemployment, we call it, which is really, okay, you're not fully laid off, you just have a partial lack of work. They've cut some hours. Well, you're still partially eligible for a prorated amount based on whatever limited hours or wages you are now receiving, either from that employer's reduced income or from outside sources of income that you might have doing any of the things that we've talked about. And so that can reduce an employer's potential unemployment insurance payments, because actually they're only paying a partial sliding scale of benefits in light of the other income source that an employee may be having. The employee should, even if they do qualify and are certifying for unemployment benefits, be truthful. And if they're making any of that outside income, the state of Michigan's unemployment insurance computer system has a notorious problem in overcharging fraud for folks who are potentially have income while they're collecting unemployment insurance. It's a case that I've been involved in for now 5 or 6 years, as the computer system's lack of capacity of getting the factual specifics down and defaulting to deny folks and defaulting to charge them with penalties for this. So all of those things could save folks not only the contention of maybe a good relationship, but also the time. I mean, an unemployment insurance misclassification determination is not going to be a quick decision, especially in light of what I imagine to be record filings. And so the benefits could all be so far delayed that it can potentially undo the need. By definition, we need this benefits now in between jobs to stave off, the worst of the worst that could happen to us. And so this, anything to reduce that delay is something that both sides should consider.
So I actually had to go through the process of filing for, or working with my wife to file her for unemployment because she works at one of the casinos and got laid off. And the system, I think that a lot of people don't understand that the system itself is, and from hearing you talk, the system is really built to be an obstacle and to make it difficult for people. What should people do if, as we're all going through this right now, and we have hundreds of thousands of people that are filing for unemployment and realizing how poorly structured this system is to get help to people quickly when they need it? What sorts of avenues? I mean, is this something that the governor can change on her own? Is this something that the legislature needs to change? What's the given that this is a problem, what's the best route to look at to try and get some positive change, take people's attention right now and let them understand that this is something that they can change, that needs to be changed?
Yes, it's very important. Every of the, let's say, dozen workers or so I've talked to since the pandemic worsened, the system is overloaded. I had somebody file a week ago and still hasn't gotten their day yet as to what day of the week they're supposed to be certifying. At least initially, to do the absolute best they can at putting up with the delay. Not only the computer systems delay for online filings, but the phone number that ends in 0017, it was notorious long before a global pandemic of hours of wait time. I do think they finally initiated some type of callback, where you can be in a queue to have an examiner call you. From somebody who's seen the inside, I can just tell you there's just not enough humans inside of there that can reach enough people before this happened. So the computer system itself, be as patient as you can with it. It has been completely bombarded. I imagine they were never equipped to deal with it properly before this, so it's only going to be a thing where there might see some crashes or it's slowing down. I don't know if it helps to go on times that might not be peak times for other people filing at all or not.
4 a.m.
Yeah. But at the same time, your broader question, I believe, is more important. This system was built and put into play in October of 2013, the Midas system. And King Midas has done nothing but destroy the lives of many people in Michigan. Without having human claims examiners, this computer system and its if-then drop-down menu approach is at one part programmed wrong and to default against workers half the time and to deter workers from collecting these benefits. But more importantly, it's rigid. It's not an easy system to go back in and program and add, oh, now voluntary leavings don't matter if it's a health field. Now you waive your reporting requirements because our economy is down. Now you don't have to look for work anymore, according to Governor Whitmer's thing, until the economy improves. You have to go through some of those requirements. Well, I want to see how that's actually going to work out for regular people, because this system is programmed by if-then algorithms that need to have SQRs and all of these things done to even change how the drawdown menus and whatnot are being viewed as employees. That's not going to be easy to do regardless. And the governor not only needs to have pressure on her to hire claims examiners and to update this system that is well recognized as broken. The subject of 2 federal class actions, one that's ongoing and a very large state class action tied to the rigidness of the system. But as somebody has admitted to me from the state of Michigan as recent as 2 weeks ago, the computer system is still being used to make decisions on non-fraud eligibility issues. And so if it's just programmed to say, hey, you worked in the healthcare field, you quit, automatic denial, without any of the caveats of what this should be created with having a global pandemic, their workers should just not be deterred and to have the thickest skin possible as to keep protesting. So when in doubt, file, keep protesting any denial, have patience with the computer system, continue to monitor your MyWham account. We have evidence that the notifications and the emails that they allege to go out when you do have an update in your account might be going to your junk folder, your spam folder. Continue to check your account even without receiving an email every day or two. Have that patience. If you are denied or while it's being held up in general, continue to certify. I'm still unemployed. I'm still looking for work. I still do not receive income. All those, I'm still able and available for work. All of those things need to still be done bi-weekly. So if and when we win your hearing or you win your decision, you'll get all of that back pay that you do not get if you just throw your hands up and say, this is ridiculously hard, but I am unemployed. Most importantly, to file as soon as you can from losing your job. The governor just extended this period to 21 days. It was previously 14 days. That's still fairly quick for people who might think, oh, I might get called back, or I have another job leave, or I'll do it when this money runs out, or something like that. When in doubt, file, because after 21 days, you're sacrificing those weeks. And that's another thing. Yep.
I'm also going to jump in. I think coming in off of that point, one really important thing, especially for even looking at the stimulus law that's being passed right now, getting yourself into the unemployment system, if you think you might be eligible, if they expand classifications, if they make it apply to 1099 workers or make it apply to a broader spectrum of healthcare workers, if you're in the system now and then later they expand the eligibility, you're more likely, I think, to get benefits than if you wait until you get classified and then somebody comes back and now you have to apply 3 months in and say, oh, I think I should have been getting money since early March. But you didn't, if you wait till you know you're eligible, it could be too late for you to get benefits.
That's right. It's right. I mean, they gave the non-business reason of why they had to go to the computer system as the economic crash of 2008. And that's what first made them look at laying off examiners and being able to handle more claims. Now we're going to see more unemployment insurance filings than even then, especially with potential expansion of categories. I have no idea, and there is no precedent as to how a computer system or any state's unemployment insurance agency is going to be able to grapple with this easily. I imagine it's going to require reprogramming. I imagine it's going to require many workers temporarily hired at claims offices throughout the state. Whatever it is, you're absolutely right. It's only going to potentially jam the system even more so the earlier your information can get in, the better.
Cool. So I just want to revisit one thing that I think we kind of blew by. When you're reporting your eligibility for work, this bi-weekly checklist you have to do, and even if you do start receiving benefits, one of those categories that it requires you to do is actively seek work. And right now we're on a indefinite shutdown in the state of Michigan. What should people be answering in that category so as not to commit fraud, so as not to give a false answer when we are currently in home isolation and being encouraged by the state not to look for work?
It's a great question. I'm hoping that the pull-down menu for those certifications has been disabled because Governor Whitmer said that the looking for work requirement is suspended. And there was precedent in that regard. The state law does say that when unemployment insurance rates exceed, I believe, 8% or 10%, then the seeking work requirement is waived. That was the case back during the crash 10 or so years ago. However, because the computer system has me nervous and worried, I do think that if the worker filing is faced with that pull-down menu and it doesn't say that it's waived, to do their best to either be able to say with a straight face that they are actually looking to see whether anything remotely is out there, putting their resume on, maybe job databases, Monster and whatnot, just something where they can say affirmatively any step that they filled out online, that they look for something or were still holding themselves out there in some regard. And that's only if the computer system hasn't adapted. Okay,
so a good time to be productive and update your resume anyway, even if you do plan on returning to your job when this crisis is over.
That's right.
All right, so I'd like to move on to our last topic, which is kind of the point of all this conversation of continuing to find flows of income during this crisis, is that we have bills to pay. And I think two of the biggest bills that people are most nervous about right now are rent payments and mortgage payments, both for a residential property and a commercial property. What kind of advice can you give to viewers when facing a rent payment coming up on the first of the month and they simply don't have the money to pay it?
It's going to be a very important topic for all of the viewers to keep an eye out on, because we are right now, luckily, having most, if not all, mortgage companies and the governor work to say that all evictions and or foreclosures are going to be stopped. I know there's moratorium on tax foreclosures. The IRS deadline is moved. All of those things are commendable and good things, but for how long will they last? And for the folks in cities where there has not been the court system saying they're going to stop evictions, what are those folks going to do? The most important thing to remember is to keep some type of communication open with either your landlord or with your bank or mortgage provider. Your mortgage provider should have some type of either policy or knowledge as to what they are allowed to, I guess, wait on or, cease enforcement of while this is going on. The landlord, even if you are in a situation where there's not a moratorium on evictions and you end up faced with, either not being able to pay rent or whatever it is, if they're not going to work with you, they're still going to have to go through the channels to try to evict you. Of course, you should always try to work with them. And to any landlord out there, please, recognize this as number one, an unprecedented time where being able to find somebody to come into that house who might be in a way better situation is not going to be as likely. Number two, you're going to still have to go in front of a judge. And the judge is still going to have to, even if there's not a moratorium in that jurisdiction, say what's going on. And if an individual says, we're doing our best to have it, we can make payments of this amount, please don't kick us out, we have family, we have other, we need shelter. Let me tell you, it's very possible that judge is going to be just as hard on that landlord as, as a moratorium, and give them time before they allow for an eviction to happen. So hopefully you can catch flies with honey. Let them know what you can make. Let them know if partial payments are possible. Let them know when you're hoping to either go back to work or otherwise, be willing to sign promissory notes that say that, if and when you're able to make payments on the amount, you'll be able to do it. But if not, if it goes into court, not only should the tenant be ready to put forth their story that says, we are dealing with an unprecedented pandemic, something that the court's never seen before, and the idea that throwing people out on the street is going to make people safer in any way during this time period is ridiculous. They can call sugar law, and even if I don't do landlord-tenant stuff, I can refer you to countless other nonprofits that are going to be able to argue things much better than me at keeping folks in their home. And so I would hope that we would all come together to figure out if and what's possible to continue as much as we can of our status quo existence, and while we're supposed to be distancing ourselves, in the meantime.
Does the same hold true for a small business owner who's maybe paying rent on an office space or a restaurant or a property that they've had to close because of the social distancing?
I would hope so. And I know that Governor Whitmer and the federal stimulus have referenced or otherwise, hoped that there'd be certain grants or other types of funds for small businesses specifically who can show, losses exactly like the one that you're talking about, that will hopefully at least let them stay in the property in the meantime. But yes, same goes for them as well.
So a point of clarity, assuming that you can get a landlord or a mortgage company to work with you about, missing payments altogether or making a partial payment, is it true that people should still be prepared that for however long we are closed down and forced to socially isolate, they are responsible for those rents and those monies during that time period, correct? So we don't get like a free month of rent or a free month of mortgage, since we're facing this situation.
Yeah, that's a really good question. I'm not sure whether I believe the moratorium on evictions would just be that the court is not going to institute any eviction proceedings during this time. Not that it's waiving any contractual obligation from either party. I could be wrong. Obviously, if I were a tenant attorney, I would argue that it might suspend it, but I don't think it speaks to saying any and all obligations are, not even retroactively, required. And I do think as a potential way to maybe work with a landlord is to say, if and when you don't evict me or institute foreclosure proceedings, I'd be willing to sign a separate agreement of payments of a lower amount of payment for the full amount. That would be one of my potential, let's call them compromises in such a system.
So, kind of again going back to the unprecedented nature of this situation. Most people have great relationships with their mortgage company, their bank, or their landlord, and those institutions are feeling the pressure just like we are. Is the best practice, if you can't work out some sort of arrangement, or if you're going to be held to a deadline or a rent payment that you simply can't make, to engage the services of an attorney or a nonprofit at that point?
I would say initially, if the landlord and or bank have expressed a firm not being able to work with you at all, that there's no wiggle room internally through their channels at all, I think the law requires the tenant to at least put notice, to have some type of communication. The landlord has to give you notice, and then the judge is going to ask you, have you guys sat down and talked about any other way that you can work out this issue? But if they're firm that they won't be able to do it, yes, to reach out to Sugar Law Center if it's an unemployment insurance hearing, to reach out to Sugar Law Center if it's a separate employment law issue. And there are countless nonprofits, Lakeshore Legal Aid. Really, you have United Community Housing Coalition. You have the Free Legal Aid Clinic as part of Wayne State. Countless nonprofits that provide free or low-cost representation during landlord-tenant cases as well.
Great. And I think that what we'll do is when we post this, we'll list some links to organizations below here. Vaughn, I have a question for you that I think would be great. So it sounds like, there are some established best practices and laws and some cracks in the system before we even get to a pandemic. What are some of the things that viewers can do to help encourage lawmakers to come up with solutions to some of these cracks in the system? Who can they reach out to? Who are the best people to contact?
Talking about people in Oakland County specifically, reach out to your state legislators, reach out to your state senators. There are a lot of solutions that can be implemented at the state level. And a lot of those people right now are not, they're all focused on these issues. They're all focused on what's going on. So this is a good time to kind of, as we're all going through this process together, I think it is really important to remember that we are talking about hundreds of thousands of people that are all going into and through the unemployment system at the same time. So if a fraction of a percentage of those people reach out to their state legislators and go, hey, look, this is a massive problem. I can't believe the system is working like this. I can't believe that things are set up like this. It's going to get a lot of attention really quickly. There's massive incentive right now to make sure that people are being taken care of as quickly as possible, because this is one of the only times in our lives where you're talking literally about just millions of people across the country who are out of work through no fault of their own, and in a situation where they can't just go back out and knock doors and look for another job. This is a time where everybody's paying attention. So start with your state legislators, state senators, talk to members of Congress. I'm worried that we're going to have, there's a problem that we saw with the 2008 crisis, where you have kind of the small response, the bigger response, the major response, and then it's like all the political will is gone and nobody wants to do anything anymore. And I think we're kind of at the second hill on that roller coaster right now at the federal level. This If this isn't the biggest response that we're going to get from Congress, it's the second biggest one. And after this, they're not going to be able to make major fixes anymore. So, reaching out and letting people know, talking about why this is messed up right now and why it's not working the way it should be, is important. And that's definitely start with your state senators, state representatives.
Cool. I think we're all, as a media guy, we're all seeing how we're being affected. Normally we'd be doing a in-person interview with cameras, and now we have to resort to video conferencing. Hence, we're seeing the need to plug in an iPhone from Tony here. So as a media professional, bravo on thinking on your feet and coming up with solutions. So wrap this up. Be going on for a while. We've been hearing federally from the White House probably a optimistic, without warrant, projection of by Easter this will be over. I think when we're listening to our governors, Governor Whitmer, and we're listening to scientists and medical professionals, odds are that this is going to be a situation that lasts for quite a bit of time. What should we be doing once we get past these initial hurdles of unemployment and finding out what this first stimulus is going to bring us? What other types of things can we be doing for ourselves to prepare for whether it's legal battles or the next phase or the next hurdle once we start to pass these windows of coverage, the 20 weeks or 26 weeks, or whatever amount of payment and time the stimulus bill that passed today is going to give us?
I think one thing that's really important for people to think about is that at this point, it's still considered relatively likely that even as the COVID-19 disease begins to sort of as we start to get a handle on it right now, that there's a possibility we could have, general resurgences of it in different areas. So it could be a situation that 6 months from now, Oakland County could have another shelter-in-place order, even if that's not something that's happening in, say, Macomb or Wayne, that you could still have something happen in Oakland where we have an outbreak and we have to shelter in place here and try and get the disease under control locally again. So I would hope that on the policy front, that the legislature considers that we may wind up in situations where we have shelter-in-place orders that are regional that we have to prepare for and expand eligibility for unemployment, because there's just ultimately there's just no arguing with this virus. It's going to do what it's going to do, and we just have to sit down and wait for it to finish and wait till we get a really good vaccine that can help protect all of us.
Tony, any thoughts on things we can do to prepare ourselves legally prior to a resurgence happening?
I definitely agree with Vaughn that this is not going to be something that's going to go away quickly, even if we're able to flatten the curve, or let's say we do a mass vaccination. The idea that people are still going to need to miss work over it, even if it's to a lesser degree, are not going away. Even if it's less people infected, they're going to need to miss work. It's something that is not only important to take care of that specific individual who might be going through a life-threatening, disease, but all of their coworkers. This is perfectly highlighting, unfortunately, America's complete backwardsness of paid sick time off, medical leave in general for its employees. We rank at the bottom or near the bottom of any type of industrialized country in the leave that we provide workers. The limited leave we do provide them under FMLA is unpaid. It just says they got to hold a job for you. And so it's going to highlight the need and hopefully make people remember that if somebody's coming to work sick, whether it's when we have this disease, a better hold of it or not, it potentially affects all of us. And if all of us get it, well, not only is it going to shut down the economy, that we presumably all need. But more importantly, it's going to make everything more expensive. It's going to make it where those folks can no longer afford to even pay other parts of the economy that are needed. And so I hope that the governor and our state, federal, local level, everybody understands that the things that are being put into play now shouldn't only always just be for emergencies. That these things can all have had an effect in limiting the emergency that ended up happening later. That it's just the right thing to do when people need to stay at home and watch their children, when people need to stay at home and take care of themselves, to have some type of net there to know that they can come back in.
Vaughn, where can people go to learn more about Oakland County Democratic Party's efforts? Where should they be communicating with you for valuable information like this webinar and other messages?
Well, there's our Facebook page, the Oakland County Democratic Party. We also, our website, ocdp.org, we're trying to use that to focus, let people know of what opportunities to volunteer there are in Oakland County, and to help coordinate response efforts. We also have an email list you can sign up for on our website. And we're going to keep communicating with people throughout the crisis and keep working on and letting people know what they can do, how they can respond, and how they can help put some of these policy positions in place at the county level and above.
All right. Thanks, everyone, for tuning in to this webinar from the Oakland County Democratic Party. We're going to be doing more of these on a semi-regular basis to help address some of the big questions that Oakland County residents are facing during this time of crisis, and what the Oakland County Democratic Party is doing to rally resources, facts, and individuals to help all of you get through this time. Thank you, and we'll see you next time.